Dive. Today, we're really digging into the Supreme Court's 2024-2025 term. Now, you've got this stable 6-3 conservative majority, right? So you might think the liberal justices are, well, quiet. But our sources show that's really not the whole story, especially not with Justice Ketanji Brown-Jackson. And here's the thing that really jumped out. She was actually the most frequent dissenter this past term.
That's right. 10 dissenting opinions offered by her. 10.
Exactly. And it's not just, disagreement for disagreement's sake. Sources are calling it a distinct alternative constitutional vision. So the real bombshell we want to unpack for you today is how these dissents function. They aren't just legal points. They feel more like a strategic blueprint, maybe. Very human-centered, looking towards the future. I want to show you why her voice, even in dissent, really matters. Okay, so let's get into it. One big theme that keeps coming up in her dissents, defending checks on executive power.
Absolutely. A strong defense.
And a really key example here is that Trump v. Kesey case.
Oh, yeah, that one was significant.
All right, so the majority basically said federal courts, they generally can't issue these super broad universal injunctions.
These orders that block a government policy for everyone. Yeah, not just the people suing.
Exactly. And the court majority framed it as like a procedural issue, court rules stuff.
But Justice Jackson saw it differently, fundamentally differently.
How so?
Well, in her solo dissent, she argued this creates, and this is her phrase, an existential threat to the rule of law.
Why? Existential threat.
Yeah. She argued it effectively lets the executive operate in what she called a zone of lawlessness.
A zone of lawlessness.
She didn't hold back, warned disaster looms, said executive power could become, quote, completely uncontainable.
So the fear is only people with resources can fight back.
Precisely. A two-tiered system. She really turned what looked like a technical procedural point into this fundamental challenge about unchecked power. It's not just rules, it's the balance of government itself.
That's a really powerful reframing. Okay, so beyond executive power, what else defines her dissenting philosophy when you look at the whole picture?
Well, I think a consistent thread is protecting vulnerable groups and really focusing on the real-world impact of the court's decisions.
Okay.
She's constantly looking at how laws affect historically marginalized communities.
Any examples spring to mind?
Well, think about cases involving, say, transgender rights or LGBTQ plus inclusion, racial discrimination. Even when the court decides not to hear a case like Nicholson v. W.L. York.
What was that one about?
It involved claims of systemic racial discrimination against Black employees. The court denied cert, refused to hear it.
And she dissented from the denial.
She did. She specifically pointed out how choosing not to hear a case can effectively shield discrimination from being reviewed. For her, the law isn't abstract. It has real, tangible effects on actual people's lives.
Interesting. So it's not just about the cases they do decide?
Not at all. And, this leads to another point. She also directly critiques the court itself, its methods, sometimes even its legitimacy.
How so?
Like in Diamond Alternative Energy v. EPA. She voiced concern that some rulings create an appearance of favoritism, her words, for moneyed interests.
That's a serious charge. Favoritism.
It is. And she suggested this could damage, judicial integrity, public trust.
And her language is often quite direct, right? I remember reading about her calling something a wrecking ball.
Exactly. That was in Trump v. American Federation of Government Employees. That kind of direct, accessible language wrecking ball, it seems very deliberate.
Why do you think she uses language like that?
Well, she seems to see it as crucial for democratic accountability, making the court's reasoning clear, understandable to the public. It's about transparency, fostering trust. That wrecking ball image, that really sticks, doesn't it?
It does. It's very visceral.
Yeah. It conveys the potential damage in a way legal jargon might not.
So wrapping this up, what's the key takeaway here for you, the listener? It feels like Justice Jackson's dissents are, well, more than just disagreements on paper.
Much more. They present this coherent, quite human-centered, alternative way of looking at the Constitution.
A kind of counter-narrative to the majority's view.
I think that's fair. One that really emphasizes real-world consequences and systemic issues.
Okay, so here's a final thought for you to chew on. Are dissents like these just footnotes, things lawyers read but that don't change much now? Or could they be something else, like those famous dissents from history? Are they maybe roadmaps, carefully drawn plans for future legal change?
Waiting perhaps for a different court, a different time, or maybe even sparking change outside the courts, like in legislation.
Yeah. what role do these powerful dissenting voices actually play in
Yeah.
keeping our democratic structure safe? Something to think about.